Good morning, and may it please the court. My name is Jeffrey Golant, and I represent the appellant, Milton Whynes. If I may, I'd like to reserve 3 minutes of my time for rebuttal. The order that is under review in this case was decided on very narrow grounds. The circuit court ruled expressly, and the transcript reflects, that in order for a individual to be protected by Section 626-9551D's prohibition on using borrower insurance information to solicit the sale of insurance, the borrower would have to allege that the borrower himself was the direct target of the solicitation. That's the issue in this case.
Wasn't the sale of insurance solicited well before this happened?
No, it wasn't, Your Honor. The insurance that caused my client's grievance was a transaction that happened long after whatever contractual arrangement between Wells Fargo and American Security. That's what brought him to seek declaratory relief.
This is a case of pure statutory interpretation, and in your brief, you rely on a Florida Administrative Code, correct?
Yes.
To buttress your argument. Well, why should I care what an administrative agency says about a statute? I can read the statute just as easily as they can read it, and their administrative code, assuming it relates to the statute, and assuming it doesn't exceed the statute, is just their opinion. Why should I care about what a state agency says about a legislative enacted? And why isn't that a violation of separation of powers?
Well,
Two questions.
The Florida Supreme Court has held in the case I cited in our brief that it's entitled to deference. Now, it isn't, to the extent that obviously the regulation cannot overrule or change the statute, but what we have here is not that situation.
But I thought deference was, if we're talking about an environmental or some type of technical expertise, what type of technical expertise do you need to read a statute about insurance? Do I have to be an insurance broker?
I don't think it's necessary to be an insurance broker to read the statute, no. But I do think that the objective of the entire statutory scheme, which the agency is charged with enforcing, does convey it with some authority and some deference. This is not a situation, although it's been presented as one, where the administrative agency sought to rewrite the statute or change what the statute said. It's simply in light of the consumer protection purposes of the statute.
Do I have to rely on the administrative code for you to be victorious in this case? What if I say, look, I only want to look at the statute. I could care less what the insurance commission, whatever Florida Financial Services says. Can you persuade based upon the statutory language?
I can, because the plain language of the statute doesn't include the words "to the borrower." That is something that the appellants are asking this court to read into the statute. And the question is whether the statute should be construed very narrowly or more broadly. We're not looking for an expansive construction of the plain language of the statute. We're looking for a common sense construction. The statute does not limit the solicitation to the borrower. And it's ironic, because in the briefs, the appellants argue that the heading of the statute is entitled Coercion of Debtors. And the argument goes, a debtor cannot be coerced if a third party is solicited. And that argument is just not logical. The way forced place insurance, as its name implies, works is a third party, a mortgage servicer, selects the insurance product and the borrower pays for it. So, and there's issues of conflict of interest and kickbacks and inflation of premium. So when a third party is making the purchasing decision and passing the bill on to the borrower, and if the borrower doesn't pay the bill, they run the risk of losing their property to foreclosure, that's a coercive situation. And
in your mind, there is no way under the statutory scheme to have forced planing of homeowners insurance?
No, there certainly is. And we've never said that there is no way to have forced placement of insurance. However, as the mortgage contract says, before insurance can be force-placed, the borrower has to fail to maintain their voluntary coverage. And it's been argued vociferously in the brief that, in the appellant's briefs, that my client didn't have appropriate insurance coverage. That's a factual question that would be very much in dispute in this case. He alleged that he did. And the reason why he brings this case is because he's gone through years of a frustrating experience where he's periodically charged by Wells Fargo for force-placed insurance, even though he maintains his own insurance coverage. So we're certainly not arguing that it's impossible to force-place insurance. We're simply arguing that before a borrower's information can be transferred to a force-placed insurer, the borrower would have to consent to that transfer. It's been argued in other cases, which are factually distinguishable, that the mortgage supplies the statutory requirement of express written consent. But it's a condition in the mortgage, even taking that argument at face value, and we would stipulate that it's not express, it's implied. But even taking that argument at face value, the mortgage does not authorize forced placement of insurance unless there's a condition that has to happen first, and that condition has to be a lapse in the borrower's voluntary coverage. Here, it's been alleged that there was no lapse, but there's been repeated forced place insurance transactions on Mr. Whynes' account. Those facts must be taken as true. When reviewing a motion to dismiss, the circuit court didn't find those facts were not true. The circuit court assumed they were true. And the argument in the appellant's brief really attempted to make a factual representation to the court to kind of overshadow and even drown out the factual scenario that we're dealing with.
Well, let's go back to my original question then. When do you contend the solicitation took place?
The solicitation takes place when, in this case, American Securities Computer Systems apparently notified Wells Fargo erroneously that Mr. Whynes didn't have insurance and communicated electronically with Wells Fargo to obtain authorization to place the insurance on Mr. Whynes' account. Now, whatever contractual arrangement that was in place between Wells Fargo and American Security would have had to have happened long before that. And it's even discussed in the papers that in testimony before New York State regulators, American Security Insurance Company's president refers to the tracking services that it provides to mortgage servicers as an acquisition expense. So according to American Security's own president, the way that they obtain force-placed insurance business from mortgage servicers is by providing these monitoring and tracking services, locating asserted lapses, in this case mistakenly asserted lapses, in the borrower's coverage, and then obtaining the authority to place that insurance. So in this case, there was a period of, some of it was within the Fladel class period, and some of it was was outside of the Fladel class period. It happened more than once. But in every situation that American Security force-placed insurance was placed, it was placed because American Security incorrectly notified Wells Fargo that Mr. Whynes did not have insurance when, in fact, he did have it.
You're down to 1:42 if you want to save that for your rebuttal.
Yes, Your Honor, I would like to do that, please. Thank you.
May it please the Court, Peter Webster on behalf of American Security Insurance Company. I'll be presenting the argument for both appellees this morning. The dispositive issue in this appeal is whether Section 626-95511D prohibits only the unconsented to use of a borrower's insurance information to solicit the sale of insurance to the borrower. The answer to that is clearly yes. Appellant has conceded that he was not solicited regarding the sale of insurance. Accordingly, this court should affirm. The issue presented is a pure question of statutory construction, which is a question of law, reviewable de novo. And of course, as this court knows, the first rule of statutory construction is that if the language of the statute is clear and unambiguous, there's no reason to resort to rules of construction. The statute must be given its plain meaning. The meaning of section 6269551(1)D is perfectly clear. It's intended to protect borrowers from the unconsented to use of their insurance information to solicit the sale of insurance to them. Because the language is clear and unambiguous, there's no reason to resort to rules of construction. The statute has to be given its plain meaning. However, a resort to the rules of statutory construction reinforces the plain meaning of the words used. The heading of section 6269551 is favored agent or insurer coercion of debtors. From that heading, it's apparent that the purpose of the section is to prevent improper coercion of the debtor or borrower to purchase insurance in connection with the loan transaction from an agent or insurer favored by the lender. And in fact, the appellant concedes that on page 10 of his reply brief. He concedes that's the purpose of this statute.
Mr. Rupp, so let me ask you this, though. This is what actually, and I suppose this is a good reason why in certain cases we have oral argument, because what your opponent suggested, and which did not jump out at me as I prepared for this oral argument, is that Mr. Whynes apparently throughout the proceedings below was trying to get somebody's attention to say, yes, I know that if I don't maintain the proper insurance, that State Farm has the right to do this, but that was in fact the whole point of the controversy below. He maintains, Mr. Whynes maintains, that he always had proper insurance. So what about that issue? And you may say, well, you know what, Judge, that really has nothing to do with the issue before this court, but.
Judge, I'm glad you asked that, because the trial judge in this case asked plaintiff's counsel exactly the same question. This is on page 150 of the record. The court said, well, whether or not that is the case, it doesn't really affect what my decision here today would be, right? Whether or not he was current or kept up his insurance or not, that really isn't the issue. And Mr. Golan, on behalf of the plaintiff, said, I agree, that's not the issue. This is a declaratory judgment action brought pursuant to section 626.9551(1)D to prevent the use of the borrower's insurance information. And unless that section covers the situation that occurred here where the appellant has conceded he was never solicited, unless that statute applies when there's no solicitation of the borrower, there's no case, and the trial judge got it right. And so
there may be an action, but not
not
pursuant to
this
this one.
action.
Well, could you address the Florida Administrative Code? and
I'd be
why-
delighted to, Judge. It simply has no bearing on the outcome of this appeal, and there are a whole bunch of reasons why. First, on its face, the rule purports to interpret section 626.9521, not section 626.9551, and the appellant has never explained, either in the trial court or here, how the rule can be read as interpreting a statute other than the statute it purports by its very language to be interpreting. Second, even if the rule could be read as purporting to interpret section 626.9551(1)D, there's no reason, as Your Honor indicated, to defer to an agency's interpretation of a statute if either the statute is plain and unambiguous and there's no need for construction, or if construction doesn't require agency expertise. That's clearly what we have here. The language of this statute could not be any clearer. Third, again, assuming that the rule can be read as purporting to interpret section 626.9551(1)D instead of The rule itself limits use of policy information only, and this is a quote, to substitute, replace, change, or extend an insurance policy. And the complaint doesn't allege the use of appellant's insurance information for any of those purposes. And finally, as Your Honor alluded to, again, assuming that the rule can be read as interpreting a statute it doesn't say it's interpreting, in that case, the rule would clearly impermissibly enlarge or modify the statute. Why is that so? First of all, because Section 626-95511D prohibits only the unconsented to use of a borrower's information to solicit the sale of insurance. The rule doesn't even mention, let alone require, a solicitation. Moreover, on its face, it's apparent that if this rule is intending to interpret Section 626-95511D, it greatly expands the scope of the prohibited activity beyond that prohibited by the section. That's explained far better in the Hofmeister decision than I could explain it to you here today. We cited that in our briefs. For all of those reasons, there's no reason to look to this rule. It just has nothing to say about the issue before the court. Back to the statute itself, I adverted to the heading of the statute and to the fact that appellant in his reply brief agrees that the purpose is what we say it is. In addition to that, paragraphs A, B, and C of subsection 1 of the statute all protect the borrower from various ways that a lender or affiliated entity might coerce the borrower into purchasing insurance from a favored agent or insurer. Paragraph A protects the borrower from being coerced into obtaining insurance from a particular insurer, agent, or broker. Paragraph B prohibits the unreasonable rejection of an insurance policy provided by the borrower. And paragraph C protects the borrower from being required directly or indirectly to pay a separate charge in connection with the handling of any insurance policy required in connection with a loan. So read in pari materia with paragraphs A, B, and C, as it must be, it's clear that paragraph D is part of a statutory scheme intended to protect the borrower from unwanted solicitations for the sale of insurance. It just couldn't be any clearer. That's the whole basis for their declaratory judgment action. I submit to your honors that the trial judge got it right. He correctly relied on the Southern District / 11th Circuit decision in Sultan and the Miami-Dade 11th Circuit decision in Hofmeister. Unless there are any questions, we request that you affirm.
Okay, thank you.
The appellees argue that the court should look at the plain meaning of the statute. And at the same time, the appellees ask the court to add words that are not in the statute. And those words are to the borrower. Those words are not in the statute. It is not in the plain language of the statute. And it is not consistent, as we've already discussed, with the goal of protecting the borrower from coercion. Another logical flaw in the argument that was just presented was that the policy wasn't intended to substitute or replace a borrower's policy. But that's exactly what force-placed insurance does. It's only available when the borrower has no policy and a policy needs to be placed in replacement of that policy.
Let me ask you this question. Let's assume, and I know you dispute this, but let's assume for argument's sake, and let's take Mr. Whynes out of it. Let's call this person Mr. Jones. Mr. Jones has this exact same mortgage with Wells Fargo. Mr. Jones just, for whatever reasons, believes that he should not maintain hazard insurance. He doesn't want to, or if he does, he was able to go online and he's got he's got $10,000 worth of hazard insurance that he's paying $100 a year for, and Wells Fargo says, wait a minute, clearly this is unacceptable, this is not in keeping with the hazard insurance requirement of the policy of insurance. In that situation, again, assuming that Mr. Jones intentionally underinsured here, what is a Wells Fargo to do in a situation like this?
In the situation Your Honor describes, Judge Sicklin, Wells Fargo is perfectly within its rights to force-placed insurance. And conversely,
Why?
Because the mortgage says so. The mortgage does impose an obligation on the borrower to maintain insurance. And if the borrower breaches that obligation, then the mortgagee is allowed to replace the insurance with force-placed insurance. There's no dispute about that.
How do they get the information to know, excuse me, that there's a necessity for that type of placement?
Well, until the recent developments in the industry, the mortgage servicer would monitor their portfolio themselves. Recently, and I think it was discussed.
You're saying that the monitoring is the problem?
The monitoring is the problem, because in this case, you have monitoring being done using systems that Mr. Whynes maintains are deeply flawed and that have failed in his situation many times. And it's being done by the insurance company that would provide the insurance and that has a business interest in procuring the insurance placement.
You're saying the monitoring is okay as long as the lender does it, not if the insurance company does it?
It's certainly okay under the statute. That would not trigger any issue of consent to the sharing of the information. So there would be no issue under the statute whatsoever if the servicer were doing its own monitoring. Now, if a third party, in this case American Security, is doing the monitoring and there's a breach of the mortgage, the issue is different. And that issue, as discussed in Sultan and in Hofmeister, was whether an actual breach of the mortgage, or I'm sorry, whether by signing the mortgage that talks about forced placement, that constitutes express written consent as required by Section 6269551. That's a different issue. But before you get to that issue, there has to be a factual scenario in which a mortgage was signed and the precondition to forced placement, lapse of the borrower's voluntary coverage, actually happened. The mortgage plainly does not authorize forced placement when the borrower maintains, as Mr. Whynes did, insurance continually. And that's the very critical distinction in this case.
But your opponent's arguing, though, but that's not how you framed your declaratory action. You were really looking for a declaration that in this particular situation, State Farm, in cooperation with American Insurance, really took advantage of the situation and did the same type of solicitation you're suggesting that the statute prohibits.
I believe that the appellees really have mischaracterized the allegations in the complaint. What the complaint alleges is that Mr. Whynes had been subjected to erroneous forced placement by an entity that he never even heard of, American Security Insurance Company. He would have never known that he was dealing with American Security Insurance Company if he had not actually taken the step of hiring a lawyer out of the frustration he was experiencing. And because he did never know that American Security Insurance Company was involved, he never had the opportunity to expressly consent to American Security's involvement, or was not given the opportunity to object to that involvement. And that's the right the statute confers. The statute requires express written consent or at least the opportunity to object. But there's no disclosure whatsoever, and it's counterintuitive that American Security is actually operating on Wells Fargo's behalf, monitoring the borrower's insurance company, and force placing insurance in the name of Wells Fargo.
Why is the provision for hazard insurance under the mortgage, why is that insufficient for consent?
It's not express written consent to disclosure to the third party that is actually receiving the information.
Well, it's consent for forced placement, isn't it?
It's consent for forced placement, it is. And it's certainly not sufficient in this factual situation.
So your theory, they'd have to have their own insurance company to be able to do it?
No, we're not saying that at all. They would.
Well, I wouldn't have presumed you would, but I mean, how would you logically do it, then they have to give that information to an insurance company at some point. So you're saying if you have a recalcitrant homeowner who does not want to do what the mortgage requires, they're not going to ever agree to send it, to that information being sent to a third party, and how would you ever enforce that forced planing then?
Well, all they have to do is either obtain consent or provide the opportunity to consent. It's a disclosure right that's provided. So what they cannot do under the statute is transfer the information and use it to procure insurance without the borrower even knowing that it was done, or provide it to that party.
What if they refuse consent?
If they refuse consent, then they don't have to make the loan. That could have been made a condition of the loan. It wouldn't have been difficult at all. And at least if that had happened, Mr. Whynes could have read his loan documents and known that the party that he had the grievance with every time he was wrongfully forced-placed insurance was American Security Insurance Company. He didn't even know that. And I would submit that under the statute, he is entitled to know that and must at least be given the opportunity to object to that. Few borrowers would, very few would, unless they have a problem, as Mr. Whynes did. But even if Mr. Whynes had consented or been given the opportunity in advance, then he wouldn't have recourse under the statute.
Okay, great. Thanks,
Thank
Ed.
you.
All right, our next one up is Reynolds versus State.